So what is the relief duty? It's a real good question. It obviously kicks in quite soon in the homeless application process, and a lot of people get bogged down and lost in this relief duty because basically councils don't follow the law. And if you think about it, the relief duty is really put in place to make it easier for councils to get rid of you without putting you into social housing or 12-month short hold tenancies, which is something that came in about 12 years ago, 13 years ago now with the Localism Act 2011. Because before that you'd get social housing if you are owed the main housing duty. But what the Conservative government have done is basically, first of all, water those duties down in 2011 to make it easier to discharge duties into the private sector. And then the 2017 Homelessness Reduction Act, which came in 2018, basically made it even easier to get rid of people that way. And if you think about it, the government had this big problem. Too many people are making homeless applications. They have two options: either increase the supply of housing to ensure that people have social housing to move into, or just make it harder to get social housing. And unfortunately they chose the latter. So that's what we're kind of left with. And I don't think housing officers like this either. It's incredibly onerous on them. There's loads of letters and additional steps they need to take, many of which are basically a waste of time. But unfortunately you do have to come to terms with the relief duty and get your head around it, because it's going to kick in, as I say, early on in the process, and depending how you play it can massively impact what kind of housing you get at the end of it, if anything. So if I just start by saying how it kicks in, you make a homeless application. That's obviously the first stage, and you can make a homeless application if you approach any department of the local authority, the local housing authority that is, ask them for help with housing, and you give them reason to believe that either you are homeless or you are threatened with homelessness, which is important to have that distinction between those two things. But if you've done that, you made a homeless application, and as I say, the Homelessness Code of Guidance makes it clear you don't actually have to do that in any particular form. The best way to do it is via email, and I did a video a couple of weeks ago just about exactly what to include in that email that you send to the council. So you've made a homeless application. Now let's set aside the threat with homelessness for a minute, because that's when the prevention duty kicks in. I'll do another video about that at some point. But the relief duty kicks in if, once you've made the homeless application, the council will start making some inquiries, and they'll essentially want to establish whether you are eligible for assistance, so that they're satisfied that you're eligible for assistance and that they're satisfied that you are indeed homeless. And it's important to understand that there's different thresholds. So when you first make the application, there only needs to be reason to believe that you might be homeless to trigger that initial duty, but then they need to satisfy themselves. And it's not about proving beyond all reasonable doubt. I mean, I might make a video about that actually, in terms of just kind of what these different thresholds are. But just basically on the balance of probabilities, they have to be satisfied that you are in fact homeless and you are in fact eligible, bearing in mind that the section 188 interim duty to accommodate, as in give emergency accommodation, kicks in earlier than this. So if there's reason to believe that you might be homeless, might be eligible for assistance and might have a priority need, the interim duty to accommodate kicks in immediately. So that will already have happened if that applies to you, and then the relief duty kicks in. But just to make the point, the relief duty kicks in for anyone who is homeless, and we'll see how Local Connection interacts with it as well. So as I say, council has now established that they're satisfied that you're homeless and you're eligible for assistance. They then need to undertake a number of duties which kind of happen simultaneously. So the relief duty is technically what is called section 189B, but there's also these simultaneous duties that kick in under section 189A. You don't need to remember that, but you'll see these kind of numbers within the letters you get from the council. So the section 189A duty is essentially for the council to carry out a decent assessment into your situation, and they need to cover at the very least why you became homeless, what type of accommodation you and your household need, and what support you might need to maintain it. And that assessment has to be done no matter what. So Local Connection has not yet kicked in, bear that in mind. If we just go back to the beginning, just to really labour this point, Local Connection does not kick in with the initial application itself. So the homeless application does not consider Local Connection. So you can apply to any council in the country, nor does it apply to that section 188 interim duty to accommodate. So if there's reasons to believe that you might be homeless, might be eligible, might be in priority need, that's when the interim duty to accommodate kicks in. Local Connection comes a little bit later down the line, as we'll see in a second. So they carried out the assessment. Once they've done the assessment, they then use that to work with you, or that's what they should do, to form a personalised housing plan. And essentially in that personalised housing plan, they will set out what steps they will take, what reasonable steps, that's the term they'll use, what reasonable steps they'll take to try and get you housed, and what reasonable steps you need to take to try and get housed as well. Now notice that it is not the same thing as having a duty to give you housing or make your secure housing for you. It's just a duty to make reasonable steps, which doesn't have a lot of teeth if you think about it. And this is why priority need is so important in this, because if you're not in priority need, so if you're not going to be owed some duty down the line anyway, the council's not terribly motivated to actually help out at this point, so you might get some kind of flimsy offers of referrals to supported accommodation. If you're really lucky, you might get some kind of support into a rent deposit scheme type place in the private rented sector, but the council doesn't have to, and because they're so strapped for cash and resources, they're only likely to help people who they are going to owe a duty to anyway down the line, and that's kind of why this kind of kicks in and why it's very unhelpful in my opinion. So they've formed this personalised housing plan with you. Now, interestingly, you can challenge the reasonable steps that the council said it will take, but you can't challenge the reasonable steps that the council says you have to take, which is really weird, but that's the way it is. And also, you can't challenge the content of that assessment. So if they make a ridiculous assessment, either they don't do it properly, or I've even seen it where they'll basically send an assessment to you which has got someone else's details kind of templated in, so that's kind of something that can happen. Legally, you can't challenge that in terms of going through that existing review process, but you can still complain about it. If it's stupid, you can still make a complaint, which is what I would do in that situation, because that assessment will then define what happens later. And you're going to get a lot of paint by numbers housing officers who, you know, they'll see, oh, you know, you've got a mental health issue, well, you need to go to mental health services, and it might be that actually, you know, from experience that doesn't work, there's no point going to it, and they'll kind of try and use that against you potentially. So that's kind of something that can kick in. So they've carried out the assessment, they've formulated this personalised housing plan with you. That's the idea. It's meant to be with you, it's meant to be a collaboration. At this point, this is when local connection first kicks in. So if you don't have local connection to the council you've approached, but you have a local connection somewhere else and it is safe for you to be referred back there, this is when the council should legally make that referral formally to that other council, and they'll send a copy of that assessment and personalised housing plan to the other council to give them a bit of a head start. But notice that is not the same thing as telling someone, oh, you've not got a local connection here, you need to go back to your home area and make an application directly. That's gatekeeping, that's not lawful. So they've done the assessment, done the personalised housing plan. This is when the relief duty is kind of, technically it's already underway by this point, but in the real world, this is kind of when they'll start mentioning it and they'll start kind of setting out what it is they're going to do, if anything. And there's about 8 or 10 different ways the relief duty can end, depending how you kind of count different things. And I'll try and go through this list to kind of give you an idea of how it can go through. So as always, just to make this easy, I'm going to give an example where I'm homeless because of fire. Because it's nice and straightforward. I'm homeless, I'm automatically in priority needs, and let's assume I'm a British national, lived here all my life, so I'm also going to be eligible, and that means that I will be owed the main housing duty, assuming I didn't set the fire myself, so I'm not intentionally homeless either. I'll probably mention that as well. And let's say I've got local connection, so all of those 5-part tests are satisfied, but that doesn't kick in yet. In the old days, 15 years ago, I'd know from day one that I'm going to be owed the main housing duty and I will get social housing, but as I say, it's not that simple anymore. There are many ways that the council can discharge their duties into the private rented sector now. So, in this situation, one of the ways that the relief duty can end, if I just start with the easy ones, is that I simply withdraw my application. So I literally write to the council and say, do you know what, I applied to you, I've changed my mind, I don't want to. It might be that you've got other alternative arrangements in place or whatever, but you just notify them that you don't want to continue the application. That's fine. They're happy, you're happy. That's what you do. And in that situation as well, the Code of Guidance says that councils should, if they lose contact with you for 56 days, they can treat your application as if it's been withdrawn, but they need to kind of attempt to actually make contact with you. And if you look at the maths of it, because you'll notice this date, this 56 days is mentioned quite a lot in the homeless application process. There's a number of points that it will kick in, but the relief duty should only last for 56 days. That's what the Code of Guidance says. That's what the law says. It's statutory guidance, so it's basically telling councils how to apply the law. So interestingly, in a situation where the council loses contact with you, technically the relief duty should have ended before they actually treat the application as closed, which I guess kind of makes it interesting, but it's just worth bearing in mind that that can happen. It's not impossible. So that's kind of option one. That ends the relief duty altogether. Another obvious one is when essentially they house you in some way, and there's a number of ways they can do that, or you might find your own housing in that situation, so you're no longer homeless, so essentially that relief duty would end in that situation as well. Another nice and simple one is where you cease to become eligible for assistance, and again this would apply to people who've got limited eligibility for housing assistance in the first place, and that kind of date expires or something in that period. It's quite unlikely, but it can happen, at which point the council would simply write to you saying you're no longer eligible for assistance, that's our job done, we'll give you some advice and assistance, but that's all we have to do. So they're the kind of nice and straightforward ones, but this is where you have to really pay attention, because what happens in this kind of next set of offers can really define what happens to you in the long term. So going back to our example, I'm homeless because of fire. therefore I'm automatically in priority need. One of the things that can happen is the council does nothing at all in that 56-day period. I do nothing at all as well. The 56-day period ends, and then the council have to make this final decision. And in that situation, the final decision would be you're owed the main housing duty. So that means you're either going to get social housing through a Part 6 offer, or you're going to get a 12-month assured short hold tenancy of suitable, appropriate housing. So those are the things that can happen. So as I say, you're owed the main housing duty, the relief duty ends. That's probably, in my opinion, that would be the best way it actually goes forward, because that's the best way of obtaining settled accommodation down the line. So that's one thing that can happen. Now, if you're not in priority need and the 56-day period ends, that's it. Nothing happens. The relief duty ends, the council's duties end to you, and there's nothing you can really do. There's no teeth to it. As I say, if you're not in priority need, there's no real teeth to the relief duty. They can say that they kind of gave you some information or whatever and they've discharged their duty, but ultimately you're still homeless. And as I say, that's just the way it can go. So you can end up with nothing at all. But equally, a number of things can happen at this point. There's two symmetrical offers which kind of replicate the main housing duty, but they're not as good. So that is a final accommodation offer, which is an offer of an assured short hold tenancy in the private sector, which is going to be for at least 6 months. Now, again, compare it to the main housing duty, you would be owed a 12-month assured short hold tenancy, but you only get a 6-month assured short hold tenancy in this case, but it's still private rented, it's still a tenancy, it's better than nothing. So that's something they can do. And equally, you've got this final Part 6 offer, which again kind of mimics the main housing duty in terms of the Part 6 route, but again it's not quite as good, because as far as I can tell, you don't get as much choice. Potentially they'll just say, hey, we've identified something, it's probably going to be a hard to let property, which means it's kind of least desirable type of social housing available, and they'll just basically, in both cases, both the final accommodation offer and the final Part 6 offer, they'll both say that's our duty done. You know, if you reject this, that's the end of the road for you. You will not get that main housing duty down the road. So in my situation, again, homes because of a fire, I'm sensible to accept whatever offer's given to me. The small print is that the council needs to tell you the consequences of rejecting that offer if they're going to try and discharge their duty. So if they haven't actually done that, if they've not written to you and told you these are the consequences of refusing this offer, then it's still open. Basically, they haven't discharged their duties yet. So that's something that can happen. The only way out of that is to essentially successfully challenge the suitability of those properties, which can be done. So if they're offering you something 200 miles away, you can challenge it and you can be successful, but ultimately you need to accept the property first and get the roof over your head, because if you lose that suitability challenge, you're stuffed, you're properly stuffed. And although suitability is possible to challenge, generally speaking, you're much better off with a solicitor. Obviously, if you can get a solicitor anyway, with any of this stuff, that's great. But particularly with suitability situations, it's quite a technical argument you potentially have to put forward, which, you know, lay people are just not going to know the background and the kind of intricacies of homelessness law to actually do that very well, in my opinion. Can be done, but I'm just saying it's quite difficult. So they're the final accommodation offer and the final Part 6 offer. But then there's this other thing which I hate, and it's kind of real sneaky, and there's not even really a term for it in the Code of Guidance. They talk about it as if it's essentially a suitable offer of accommodation which is likely to be available for 6 months. And I'm going to call this an informal offer, because it's not called anything else to make it nice and tidy. They just kind of call it this long kind of thing. And this is where you really need to pay attention, because in my situation of my house burning down, I would refuse that offer, of that informal offer. I would refuse it because I know that once I refuse it, the council will end the relief duty, and then they'll have to make a final decision about my homeless application, and at the very least I'd be owed a main housing duty. But in this situation, because I refused the informal offer, I don't get the normal main housing duty. What I in effect get is a final accommodation offer or a final Part 6 offer, and the informal offer is going to be something like, you know, some sort of supported accommodation like a YMCA or something like that. Or they might have secured, you know, they might have kind of talked to my family and said, oh, you know, your mum's got a spare room in her house, she's happy for you to live there for 6 months. I'd be like, no thanks, I'd rather have long-term accommodation, thanks very much. And so that's kind of how it can kick in. So as I say, if you can accept that offer, fine. If that's a suitable offer for you, if that works for you, then great. But if it's not going to be something which is long term, in my opinion, it'd be sensible to refuse it in this situation, because you know you're going to be owed that main duty, even though it's watered down. But this is where it gets really tricky, because I know that in this situation, because my house is burnt down, I'm automatically in priority need. It gets much more difficult if that's not so clear cut. So if I'm arguing that I'm in priority need because my mental health is poor or something like that, that is not going to be guaranteed. And so in one sense, you've got this situation where it is a bird in hand worth two in the bush. You know, that's essentially what you've got. Is this offer of supported accommodation better than nothing? or am I actually better off waiting to try and get this better offer? But as I say, it becomes very tricky, and I can't give advice about this. Obviously, this is not legal advice anyway. But because I don't, because every situation's different, and because it's not always clear whether you're in priority need or not, this is why you have to be so careful. So what you can do in those situations, I guess, is just to bear in mind is that you can still apply to supported accommodation without having to go through the council. So if they say, well, this is your only offer, that's not true. You can still go to that YMCA and apply directly, most probably. I know some supported accommodation have got kind of different referral mechanisms, but most supported accommodation you can apply to anyway. So you might still kind of turn it down and say, well, do you know what? I'm going to just hedge my bets here and see if I actually end up with a better offer if I refuse that suitable offer, that informal offer. So that's kind of something to bear in mind as well. With this as well, there's actually two ways that the relief duty can end, which I don't really think happen in practice. So one of the ways is that, and again, I just don't legally see how it fits in any kind of real situation, but basically the code of guidance says that the relief duty ends if you become intentionally homeless from accommodation that's been secured by the local authority. Now, we know this doesn't apply to interim accommodation because you can't be found intentionally homeless from interim accommodation. That's just the way it works. It's just not a settled accommodation. It's not possible. They might put you in emergency accommodation, you punch the hotel manager in the face, you quite rightly get evicted from the hotel or kicked out or whatever, and you probably quite rightly get legal proceedings against you in terms of the assault, but that doesn't make you intentionally homeless. Again, I've done another video I've done several videos about intentional homelessness at various points, so that's kind of what's worth saying. So in the real world, I don't see what situation where this could possibly kick in, but it's in the code of guidance. And also you've got this idea of unreasonably refusing to cooperate with the council, because they've set out the steps that you're supposed to take and the steps that they're supposed to take, and if you refuse to take those steps, then they can say that you've unreasonably refused to cooperate. However, it's a lot of work basically for a housing officer to go through that rigmarole. There's a lot of letters they have to fill and kind of chances they need to give you. They need to notify you and warn you and all that sort of stuff. So I guess, again, in the real world, I don't think that's actually going to be a very common situation, but it's in there. And as I say, it's just kind of worth bearing that in mind as well. So those are kind of situations that the relief duty ends. As I say, it should end on day 57 in effect, after 56 days of the relief duty kicking in. And just to labour the point again, you make a homeless application on the 1st of January, the relief duty might not kick in until 15th of January, if the question of whether you're eligible and homeless is actually quite a complicated one, because it can be complex. It's not usually, but it can be. So if there might be a bit of a delay there. But once that relief duty kicks in, it should be ending after 56 days, and the code of guidance says the final decision should be made on day 57 unless there is real complexity to your situation, in which case there can be up to an additional 3 weeks. But that's not going to be very common in the real world. However, what is common in the real world is loads of people just staying in relief duty for months. We've seen people in the relief duty for over a year. That is automatically maladministration, which means that you will be owed some kind of compensation if you take your complaint to the LGO. You have to go through the internal complaints process first, but there's a few £100s in it if nothing else. And you'll also potentially push up the standards of service, because it won't just be you who's in that boat. There'll be lots of people, most probably. So that's something you can bear in mind as well. So in a situation where you've been in relief duty for months, you're owed the main, or you're going to be owed the main housing duty, it's worth just complaining, because what's going to happen is they're going to have no choice but to end the relief duty, make a final decision, which if you're going to be owed the main housing duty because you're automatically in priority need, you're not intentionally homeless and so on, then that's going to be the best way to play it. But it leaves a lot of people in limbo, and as I say, there's no kind of one-size-fits-all bit of information that could help you out in that situation, because there's a whole load of unknowns. This is why I hate the relief duty, or one of the reasons why I hate the relief duty so much, is it disempowers people. It actually makes that power imbalance even worse between the council and the homeless applicant, because as a homeless applicant you just don't know what's going to happen, so you're having to make these life decisions. Where do I live? What area do I go and live in? Do I accept the offer of accommodation 200 miles away? And you don't have the full information to actually make that call, and I hate it for that reason. It's terrible, and as I say, it's also convoluted and onerous and everything else as well. So it doesn't result in more people getting housed than were being housed before. It's just this nonsense of really just watering down those previous duties that are owed to people, and kind of calling it the relief duty as if the council's actually helping you. Calling it the Homelessness Reduction Act as if it's actually reducing homelessness. It's not. Homelessness is still going way up, and I don't see how the HRA has actually improved that at all. So anyway, hopefully that helps. Keep the questions coming in. As I say, it's a complicated topic on this one, so if you've got any questions, we'll take the questions to the live stream every Thursday. So if you just put a question in the comments, as always, don't put personal data in the comments. You don't have to. You can get the same answer just by asking a question. What if someone was in this situation and this is what was going to happen? Because we have a mixture of people who are homeless and going through this process, and also professionals who are asking on behalf of their clients. It's just a good way of keeping your personal data safe. I don't want people to have to put their personal data online on YouTube in order to get a sensible answer. So put a question in, just call it a what if question, technical question or whatever about someone else, and you'll get the same answer. We'll take it to the weekly live stream, 7:30 every Thursday, and hopefully give you a good answer there.